What if I told you that getting denied credit could be your greatest legal opportunity if you know how to respond? Now, in this video, I'm going to break down what an adverse action notice really means, how to challenge the denial using federal laws, and how to flip the script, getting your application reconsidered or even suing for damages. Now, I've studied consumer law, credit reporting agencies, and regulations and lender obligations, and I'm here to turn a no into power. Now, before we dive into this video, make sure to like the video, make sure to hit the subscribe button, make sure to tap in so that we can be at the top of the algorithm. You understand me? We want to be at the top of the algorithm because nobody talks about these concepts and breaks it down as simple as possible so that people can actually take action. No matter what anybody says, I have people who DM me all the time and say, this, that, and the third, but it's just like, yo, if you actually watch the videos, you'll understand that it's something, it's really that plain and simple. I mean, yes, it may seem complex because of the certain jargon and language and this, that, and the third, but if you actually were to look at the information and then do your own research, you'll be like, okay, everything that Nicholas is saying makes sense, okay? And to be honest, I'm not really trying to reach the people who aren't on the same exact frequency. You know, if you know it, if you got it, you got it. If you don't got it, oh well. All right. And for those of you guys that are watching, that's how you got to maneuver. All right. So my object and goal today is to help people understand the aspect of denials and how to pretty much use the denials against them in some way, shape, or form, get something back for it. Now, this is not legal advice. This is not financial advice. Do not employ these strategies unless you understand any and everything that I'm talking about and you're willing to do that extra due diligence. All right. So what we're going to be talking about is what an adverse action notice is, when to expect it. We're going to talk about why denials can be legally invalid. We could talk about the aspect on how to respond and demand proof. And then lastly, we're going to talk about turning a denial into legal leverage. So make sure you stay all the way to the end so that you can get this game that nobody is talking about. All right, bet. So let's dive straight in. Now, what is an adverse action? You dig me? Let me go ahead and pull it up. Adverse action is a denial of credit, loan, or financial service. So typically when you apply for a loan and you get denied, they're going to send you, that's technically an adverse action, okay? And if they're going to do something adversely to you, which is essentially the opposite of beneficial to you, then they have to notify you, okay? And if they do that, they must give you notice of their adverse action according to the Equal Opportunity Act, or the ECOA. All right, so I'll pull that up real quick. ECOA, Equal Opportunity Act, just for the viewers to see. You dig me? So the Equal Opportunity Act is a U.S. law that prohibits discrimination in any aspect of a credit transaction. Notice how it says in any, prohibits discrimination in any aspect. You dig me? So it makes it illegal for creditors to deny credit or charge different terms based on the applicant's race, color, religion, national origin, sex, marital status, age, and receipt of public assistance. Okay. Now, the one thing that they don't talk about is the aspect of your income. Okay. But we're going to talk about that in a second, diving into the considerations. But you can find this either, you can just Google ECOA like I did, or you can go to 15 USC 1691, my baby, scope of prohibition. And specifically, or actually, let's go back one. Specifically, you can go to D, okay? Or you can just look at this entire section here, okay? But the overall, general, space of, okay, bet, where can I find this? You can just come to 15 USC 1691, and you could just go from there. All right? Now, let's just talk about the aspect of what the notice should say on there. The notice should give specific reasons for denial. So if you are denied credit, they must provide those proper, reasons as to why they denied you. And it can't be on the aspect of something that isn't considered a factor. Okay. We'll talk about that in a second. Also, your right to receive a free credit report, that's basic, and contact info of the credit bureau used. So a part of that adverse action letter, should be something they should send immediately after denying you. They're supposed to put where they got their information from. They got to give specific reasons. Okay. Now, usually most people crumble when they get denied, but this letter is kind of like that legal doorway to figure out, okay, bet what is it that they are denying me for? All right. Now, give me 1 second. This is what I want to do. Here's why denials can be legally invalid. Okay. Number one, the question that you can always ask is if they provide all the disclosures according to 15 U.S.C. 1601 under the Truth in Lending Act. Now, under the Truth in Lending Act, it requires lenders to provide any and all disclosures, any and all documentary evidence about the lending aspect of it. Now, part of the disclosures that is required is, okay, where is the origin of the financing? Where is the origin of the funding? Okay. And one of the things that they'll say is that you aren't creditworthy, or that there's something on your credit report that's keeping them from allowing you to get credit. Okay. But you can easily argue that that shouldn't even be a factor, given the fact that it has nothing to do as to where they actually receive the money. Okay. If they are getting the money from their own reserves, then that makes sense. But what if I told you that they wasn't getting their money from their reserves? What if I told you that they was getting their money from your signature, and your energy was the one that actually created the credit? So when you start to challenge them and ask for the disclosure as to the origin of the money, then their whole argument of, okay, well, we can't loan you because you don't pay back your debts, it just doesn't make sense, because there is no debt to be paid back. You understand me? So this is why you ask for that full disclosure. Okay. Well, what other angle did I want to go? Okay. Okay. And another thing in terms of disclosure is, they'll try to challenge and say that they are risking their money. But, if you are the one that's funding the transaction, are they really risking their money? Is there any risk involved? And that's the hard part. A lot of people don't know to take that angle when it comes to a denial. They know, okay, bet, like, I shouldn't be denied, but all they can do is just complain and get emotional about it. But what angle would you take? This is the angle I would take. Are you risking your money? Why are you worried about my creditworthiness and my proof of income if the reality is you use me as proof of income? Then the other premise is, okay, bet, if you're going to use my promissory note, whatever you want to call it, if you're going to use that as a financial asset, why can't I? If you're going to use that as proof of income to the Federal Reserve, why can't I? Oh, I need to see that you have good credit. But that shouldn't even matter. But then there's laws under 12 U.S.C. 18.3.1, if I'm correct, that pretty much talks about the risk factors. And I may talk about it, maybe not in this video, maybe on the aspect maybe on my Twitch. I'll talk a little bit about that. So maybe a little bit after this video. Most people don't know is I get on Twitch, do these live, and then answer questions after the video. So yeah, make sure you guys hit the Twitch link down below and shoot a follow. So here are some of the things that they will, some of the reasons that they will deny you for. They'll deny you for insufficient credit history. Okay. So one of the things they'll say is you don't have enough established credit for the lender to assess your reliability. Okay. Technically, it's not illegal to do this, but they must, under 15 U.S.C. 1691 D2, they must clearly explain this reason. They cannot just say, okay, you don't have enough established credit. They really got to break it down. Okay. Another thing they'll say is your score falls below an approval threshold. Okay. They'll say your score is too low. You can challenge, okay, was the score based on inaccurate or outdated info? If so, then it's two things you can do. You can challenge them based on whether the info was inaccurate or outdated, or you can just go ahead and send a letter to the credit bureau and challenge the credit bureaus first, and then circle back under 15 U.S.C. 1681I, okay? Another thing they'll say is, okay, you have high debt to income ratio. meaning your income can't reasonably support the debt. And here's what you will move and say, okay, bet. You can request documentation on how the debt to income was calculated. And sometimes unverified debts will inflate your debt to income ratio, such as those debt collectors, such as things that, and then also those debts that have been charged off technically is not a debt that should be applied to your debt to income ratio. Okay. This is why I teach you guys about debt, so that you guys know how to know when a debt is unverifiable. Another aspect is when you have delinquent or derogatory accounts. So they'll say, okay, you have past due, charged off, or collection accounts. So this right here, this is when you use 15 USC 1692G to validate those debts on your own. But then you want to challenge whether that reporting is accurate. And these are things that you must do. Okay, you must, if you have these things in your credit report, you do want to challenge to get those things off. And it does make your argument much easier after the fact about the denial. Okay, sometimes people look at it and they say, well, can I just argue with them about these things myself and get the denial off? Well, you know, you really can't. I mean, you can, but it's better if you kind of just like remove whatever they're deeming as something risk or unreliable, and then kind of going back and applying. Okay. So it's important that you get the adverse action notice so that you know exactly what to target. Sometimes you can use that as an aspect to target it. All right. Then they're going to say something like a bankruptcy filing. So usually if you have a prior bankruptcy, they may view you as risky. Okay. And notice this cannot be a sole reason if other strong factors exist. So this may raise that fair lending issue. So in most cases, yes, you will get denied for bankruptcy, but you can easily argue that that wouldn't be considered fair. All right. They'll also say, okay, too many recent inquiries. This is typically very common, because I'll say that even though you can argue that inquiry shouldn't be a factor, when you get to a certain point, just their algorithm is just going to automatically deny you. So if you have 5 inquiries on your credit report, they may automatically deny you. Okay. And that is easily fixed by calling the credit bureaus a couple of times and telling them to remove those unauthorized inquiries and then trying again. Okay. Unstable employment or income. So if you have inconsistent or insufficient job income, this right here is something where you can request that specific underwriting guidelines to determine whether they deviated from like a standard review of your income. But you can also argue that under 15 U.S.C. 1691 that they cannot use that as a factor. That technically is discrimination. Okay. Another thing, okay, mismatch between the application and the credit file. If the info on your credit report didn't match what you submitted, then this happens when there is a mix-up between that credit file and the information that they received. And this is something you can easily challenge as well using, Credit Repair, Fair Credit Reporting Act disputes. Okay. And then another thing is, and this is what I will be very strategic of, is when you have no verifiable identity or an incomplete application. Okay. So they'll try to use and say, oh, we couldn't verify your identity. And essentially what you want to do is just give them the proof of your identity. And if it's already provided, then you can just cite a failure to properly review under the Fair Credit Reporting Act or the Equal Opportunity Act. So those are a couple of things that they'll do. I also put together like a challenge letter, throw it in to complete that guide as well. But just kind of moving on. Okay. Another thing is you want to ask them, okay, bet, did you perform a lawful review of my credit file? And a lawful review of my credit file is you moving by the things based on your rights as a consumer. Okay. Did you properly review it, and how did you review it? Okay. Another thing, you want to ask them, okay, bet, did you make those decisions based off that unverified data? Did you make decisions based off of outdated data? Okay. Also at the same time, did they discriminate? Okay. Was there some type of discrimination where you just denied me just because of my zip code, just denied me based off of who I was? Because some people get denied and they actually don't have bad credit. They have good credit. They don't have that much inquiries. Yes, they may not have as much credit as they hope they will have, but they still have good credit. If you're a person that gets denied and you have good credit and you don't meet none of those negative factors, this is a very easy argument to get them to reassess your application. Okay. And then lastly, the no proof that they use their own money to fund, meaning no standing to deny. And that's one of the biggest things to challenge when it comes to a denial is you start to challenge, okay, the source of the funds, the source of the income. If you guys are going to loan me money, then show me that you're loaning me money and not actually using me to loan me money. Because we already know that under 12 USC 1431, my baby, 12 USC 1431, it says, look, each federal home loan bank shall have the power subject to the rules and regulations prescribed by the director to borrow and give securities, therefore, and to pay interest thereon, to issue debentures, bonds, and other obligations upon such terms and conditions as the director may approve. All right. So the key things is that their powers and duties is to borrow and give securities. The question is, okay, what is a security? A security means money in this case, or in banking terms, security is money. And we already know under modern money mechanics, we already know under the Federal Reserve Act, Section 16, we already know, that the money is not being loaned by them. So it's an easy challenge because these are questions that they cannot answer, or they can or are supposed to answer, but they won't. Okay. It won't be something where you're going to tell them, hey, did you do this? And they're going to say, you know what, you're right. And they're going to just approve you. No, you may need to be willing to go the distance. So to borrow and give securities doesn't say loan securities. Did you guys gather that? Okay. So that's under 12 USC 1431. This is just one of the first, codes that I had particularly seen when it pertained to the truth behind the banking system. Okay. But this will probably be an argument that you can easily do the things on the back end, which what I prefer one to do is to do the things that they say is a factor. So if they're saying that you have a charge off, just send a debt validation letter. If they're saying, because obviously if this bank is going to have a problem with it, then the next bank that you apply to is going to have a problem as well. Okay. So if the next bank is going to have a problem, then just do what it is that you need to do. Okay, so this is why we have a conversation about debt. This is why we have a conversation about charge off. This is why we have a conversation about communicating with debt collectors, because these are one of the key things that they'll try to use against you. And instead of you getting mad that they're using these things against you, take responsibility and challenge those debt collectors, challenge those charge offs. Take the information that you learn and start to execute on these things. You dig me? So here's the biggest thing. If they aren't lending their own money, what are they really denying? Okay. Another thing I want to talk about is 12 USC 1831. So there's also 12 USC 1831, but I want to find, what do I want to find? Just for time's sakes, I probably won't do it in this video. I may do a separate video talking about this, like a part 2. But they have their own, I just haven't reviewed this in so long, but they have their own risk factors. Okay. That they do more on the policy side of things, and they kind of follow policies and regulations, and now policies and regulations don't apply to you unless you are, the bank or in the bank. If you're outside of that, then you really don't have to adhere to their policies. Yeah, they may have to make decisions based off of their risk, but if their risk is not, if they're not risking anything, then it really doesn't apply to you or them in this case, especially if when you apply, no matter what, that money gets released to them, no matter what, they still have that application that is a financial asset to them. You dig what I'm saying? So, boom, if you gotten all the way this far, all my Twitch people that's here, you guys can disregard this, but if you've gotten all the way this far, make sure to hit the subscribe button. Make sure to hit the like button, my baby, because what we're about to talk about is how to respond and demand proof the proper way. We're going to talk about it in the aspect of the legal merit behind it, okay? Because a lot of people will talk about that you can't do this and you can't do that, and the theories behind it and the mindset behind it, but nobody ever tells you exactly what you should do in event you get denied for credit and you are pissed off and tired of getting denied for credit. How to properly go about it. All right. Now, number one, if you get an adverse action letter, okay, well, if you get denied, you want to either wait for the adverse action letter, give them about 14 to 30 days to send you an adverse action letter. And then when you get that adverse action letter, you want to read it and find out exactly what it is. All right. But you also want to challenge that adverse action letter, especially if it's not clear and they're not telling you exactly why they denied you. You want to send an adverse action letter and you want to reference the Equal Opportunity Act under 15 U.S.C. 1691. Okay. Challenge them directly. You want to demand underwriting criteria and explanation. Okay, it's different than saying, oh, the inquiries, this, that, and the third, but you want to know exactly what the underwriter is looking for, not only for you, but even if you're in a space where you're helping other people, if you want to tell your family to apply, you have a right to know exactly what the underwriter is looking for so you can focus on that. All right. You want to request a copy of your credit report and lending file used. I need to see what you're looking at. I don't want you to just tell me, oh, you have too many inquiries, you have this, you have that. No, I want you to show me exactly where you found that info. And I want to know who gave you that info, my baby. Step two, you want to then dispute that credit report data that they used if it was falsely misused under 15 USC 1681I. Under 15 USC 1681I, what makes it powerful to challenge your credit is the fact that how I'm asking these debt collectors the same exact questions. We take the credit bureaus through the same exact thing. And most of the times credit bureaus do not provide this. They do not do what it is that they need to do, their duty and obligation as a credit bureau. So typically, except for Experian is probably one of the people that, especially what I've heard from an attorney who specifically worked with the credit bureaus on their cases. She said, look, TransUnion, Equifax, oh, they'll settle fast. But Experian, on the other hand, they'll take you there. Because do you know how much attorneys charge credit bureaus and debt collectors? Attorneys will charge them $800 to $1,500 an hour. So if you think about it, if I'm only suing you for $2,000, a lot of the attorneys will say, look, man, you can either pay me another $2,000 to take this all the way, or you could just pay them. I think that's the best. It's the job of the attorney to do what's best of the client. Okay. So do I want my client to end up spending a lot of money, or do I want my client to pay me? No, I mean, of course I want to get paid, but Number three, you want to send a conditional acceptance for that loan denial. So one of the things that you can ask in your conditional acceptance is, hey, did you use your depositor's funds or credit created from my signature? It's a key question that they must ask. And if it goes unanswered, then it stands in truth. Okay. This is why you could pair an affidavit of truth. You could pair what you see and known to be truth. And if it goes unrebutted, then it's really setting up a case for you to sue them for their violation, misrepresentation, unwillingness to answer, my baby. And then step four, you want to demand lawful consideration and accounting. What is lawful consideration? Lawful consideration is, hey, was there an exchange? Would there have been an exchange? And again, they say, well, as soon as they deny me, I mean, it's nothing for me to really say. No, it is. It's a lot for you to say and a lot for you to ask. But here's the thing. Yes, you get denied. And yes, we can easily argue some of these things and answer these questions. But if you're not willing to do the actual process and write the letters and send it to the company and take them through the administrative process and potentially go to distance and take them to court and build up evidence so you can take them to court, then don't do this. There's no point in you doing this just so you can get wrapped up in your head and so emotional about, oh, I know the truth. And then what you're going to do as soon as they deny you, you're not going to execute any of the steps that I just talked about. You're probably going to go and just complain and then slide in my DMs and say, well, how do you actually do it? Well, damn, did you watch the video? You know what I mean? Like, that's why it's all about a frequency thing. Even if you don't understand it now, when you go and do some due diligence and you come back to the video, it's like, damn, he really did tell me everything. Okay. I'm not at all saying it's easy. Okay. This is why I'll make multiple videos saying the same things, because one topic can probably lead somebody to finally say, you know what? Damn, he really is hitting it on the head. And that's my goal. Maybe I'll start off and talk about certain things and say, you know what, boom, I'm talking about this specifically, but I'm always going to divert it back to the administrative process, how to do it properly. All this stuff is broken down in my Complete That guide. And if you have the Complete That guide, it's going to be resources and templates along with the YouTube videos. Oh man, that's a steal. Okay. So when they say no, you pretty much hold them accountable. Now let's talk about turning that denial into a legal leverage. Now, if they do not respond properly, which you do want, if someone comes to me and says, well, I sent this and they ignored me and it's been X amount of months and I haven't gotten no response, then, oh man, this is exactly what you need to do. It's not that you come to me and you start complaining. You start to truly, that's when you start getting on the gear. That's when you take it to a next gear. Because I'm going to ask you directly, did you sue them? Did you try? Oh, well, no, I was just waiting on. See, you're waiting on them to give you permission. Stop giving them permission. Or stop waiting. My bad, I didn't mean to do that to your ears. But if they don't respond, the first and simple thing you can do is file a complaint with the CFPB or the FTC. Best to do it with the CFPB. More likely, something is not going to happen right away, okay? This is just you moving in honor and building a case, okay? If something happens, great. If it doesn't, great. You're building your case. Then you want to prepare a notice of intent to sue under the Equal Opportunity Act or the Fair Credit Reporting Act, okay? You want to ask for damages plus reconsideration, okay? You want to use that paper trail from you asking them those questions about the adverse action letter, what they sent you over time, when they sent you things, and that notice of intent to sue, you giving them another opportunity to cure. You want to use that as a paper trail for small claims or a federal complaint, or if you want to do an administrative lien. And you can also push for reconsideration with stronger terms. So understand that a denial without lawful basis equals damages in court. They have actually harmed you when they deny you. Not only that, they have stolen from you. And I don't mean to get you emotional, but when I get you emotional, it's so that you can start to treat things like, damn, okay, they are doing that to me, but I'm also doing it to myself as well. It's like going to the gym. There's people who get mad because they're gaining weight. Oh, they're making things not nutritious. What am I supposed to do? Someone say, well, I'm fat because I'm in America. Like, so you're a product of your environment? I don't know if y'all seen that TikTok, but look, are you a product of your environment? Is that your excuse? Because you live in America? Stop it. Stop waiting on somebody to hand you your plate and create your own plate. Okay? Because those same people will get that plate of food, right, of opportunity, and they decide not to eat it. If it was some healthy food, some nutritious food that'll make you stronger, better, they'll decide to say, you know what? I want this plate that does nothing for me, doesn't serve me, doesn't make me healthy. We got people in the fitness industry right now who can give you a whole nutrition plan on how to lose weight and then a workout plan. And some people will say, well, I ain't doing that. Right after that, they're going to go to McDonald's. Hey, well, that's not fun to me. And that's exactly why you're fat, my baby. And I'm not here to fat shame. I don't care what you do with your body. Just don't complain about it. That one's for you. Now that we understand that denials is just the beginning, when you know consumer law, that's literally just the start of a legal process and in the start of you being able to potentially sue them, or better yet, know exactly what you need to do so that you can get approved next time. You now want to understand that you can now flip the script, assert your rights, and never let the system say no without a fight. If you truly want to win, you got to be willing to fight. You got to be willing to take them to the task. You got to be willing to hold them accountable. And if you're not willing to do that, do not complain. If you're not willing to go to the gym and work that body out, then don't complain. If you're not willing to do the due diligence, to learn how to communicate with a debt collector, credit bureau, a bank, don't complain to them. You should be complaining. You should be getting mad at yourself. You feel me? Now that we gotten all the way to the end, if you got all the way to the end, you're the real one. All right, all my people that's in the Twitch, y'all real too. Dig me? First things first, go ahead and tap into the Twitch down below. Hit the follow button. Road to affiliate. Number 2, if you want to tap in with the complete that guide, I'm going to put a credit denial response kit within the next couple of days. I'm going to put it together, throw it in a complete that guide. So if you don't have the complete that guide already, go ahead and tap in. Tap in now, because I'm thinking about taking that. Well, I'm not thinking about it. The complete that guide is going to be on a subscription model, because I think that there's some people that purchase the complete that guide and they don't use it properly. So every time you see that number ding on your screen, you're gonna be like, all right, bet, damn, let me go read this so I don't have to keep doing this for another month. Because to be honest, you should have it for a little bit and then boom, take what it is that you need and keep it moving. I might have had this for a lifetime, and then a year later you say, I bought this a couple months ago. I look, it's 12 months ago, and I can't get into it. Well, damn, I gave it to you for that price point and you decided not to use it. It wasn't that important to you. Yeah, so I'm gonna hit you in the head every time you don't take it serious. Okay, and maybe you'll say, you know what, damn, let me actually watch his YouTube videos. But either way, I appreciate it either way. Appreciate the support, the love. Anybody who taps into the complete that guide, buys my product and services, I'm still gonna hold you accountable. Tap in with the complete that guide. Number 2, if you want to work with me one-on-one, whether it's credit, funding, and I'm also opening up a creator mentorship. So if you're looking to be a creator, you're looking to get to 300,000 followers, you're looking to get to 100,000 followers and be able to market your business using or becoming a creator, that is another mentorship I'm opening up as well. Okay, it'll be custom for certain people if you tap in early, but when it's fully built out, just know it's probably going to be very exclusive. Number 3, if you want to follow me on Instagram, tap in at biz.nick on Instagram. Also tap into the Twitch again if you want to see the live breakdowns. Okay, my last question is, make sure have you ever been denied for credit and didn't know exactly what to do, how to respond? Comment below, let us know your situation. If there's any new laws that I should talk about, tap in the comment section. If you gotten all the way to the end, comment the word reconsider below if you've been denied unfairly. Switching it up on y'all. Remember to like, subscribe, because rejection is fuel for remedy when you know the game. I love you guys, and I'll see you in the next one.